Hello, welcome to our webinar, Cannaployment, the rise of cannabis employment class actions and how you can protect your business. My name is Janet Jackim. I'm a partner and the co-chair of the Cannabis Practice Group of the Zuber Lawler law firm. Zuber Lawler is one of the most selective law firms in the US, representing clients throughout the world from 8 offices across the US. Zuber Lawler focuses on emerging industries and technologies, including, of course, cannabis, psychedelics, clean tech, cryptocurrency, and AI. I'm honored to have the opportunity to moderate today's panel of experts from Greenleaf HR, Lawler Hire, and Zuber Lawler to tackle our topic, which is basically cannabis employment class actions. I'm required, unfortunately, to say some quick disclaimers to you. So hang in for just a minute. The opinions expressed are of the individuals and not of any company associated with them. We do not encourage the use of illegal drugs, including cannabis, and we suggest that you consult your healthcare provider and attorney if you choose to use cannabis. Nothing in this presentation creates an attorney or fiduciary relationship, but please seek the advice of your own professionals if we can't answer your questions today. I'd like to first lay the foundation for our panelists' discussion by beginning with their brief introduction of themselves. Mike, you want to take it away?
Sure. Thank you for having me, Janet. Hi, my name is Mike Siebel. I'm a managing partner of a company called Lawler Hire. We are one of the largest, if not the largest, recruitment partner in the cannabis space, as well as one of the largest HR advisory firms supporting everything from institutional, public MSOs, all the way to inception stage and back of a napkin. Thank you for having me. I'm very excited about this topic specifically.
Thank you. Brian.
Yes. Hi, my name is Brian Beck. I am a partner at Zuber Lawler along with Janet. Janet Jackim, not Janet Lang. Janet Jackim already kind of gave you the overview of our firm. My particular specialty is in litigation, especially intellectual property, commercial, and to some extent labor and employment litigation, including some large cases recently, class actions concerning the Illinois Biometric Information Privacy Act, a lawsuit involving the status of employees, external employees as independent contractors or employees, and what the hiring company did that was wrong to try to deal with that problem, and other assorted kind of labor and employment issues, as well as patent and trademark cases concerning cannabis and various other cases along those lines. So happy to be here, coming in to take over for Raza Lawrence, and happy to answer any of your questions regarding litigation in the cannabis and labor and employment space as best I can.
Thank you, Janet. Another Janet.
Hi, thank you for having us. I'm a human resources consultant with Greenleaf HR, and I assist clients all over the country with employment law compliance issues, and I am here today to help support this group and to ensure that you understand some of the things that you can do to help mitigate any employment law issues, and some of the basics that can be administered to keep you out of any kind of non-compliance concerns. Thank you very much for having us. Appreciate it.
And last, Greg.
Good morning, everyone. My name is Greg Cowan. I'm a business consultant with Greenleaf HR. Greenleaf HR is an HR outsourcing company for the cannabis industry. We provide customizable solutions for payroll, HR advisory, employee benefits, and risk management services including safety and workers' compensation insurance. So I'm excited to be a panelist this morning, and I look forward to a great discussion.
Thank you. That is an impressive panel. Thank you, panelists. Hey, audience, if you can still hear me, please use the question and answers in the chat function to submit questions to us that we hope we can answer. All right, we get on with it. Our topic today on the intersection of employment, class action lawsuits, and the cannabis industry. We first need to define that legal niche called a class action, what it is, how it arises. Second, our panelists will give you various warnings on the implications of a class action. And third, we want to give you takeaways that can help you and your company avoid or at least minimize the effects of a class action lawsuit. So let's talk about what is a class action lawsuit. You know, it's a collectively brought kind of lawsuit, not very typical, not very frequently seen, but it's very effective. It's collectively brought by a group of people or entities who have suffered similar harm, and it's against a defendant or defendants. This legal mechanism allows individuals or entities with common claims to consolidate their grievances into a single lawsuit, typically led by one or a few of the representative plaintiffs who act on behalf of the entire group, thus the name class. Class actions are often used when individual lawsuits would be impractical due to the large number of affected parties or the similarity of their claims. They are particularly common in cases involving consumer rights and product liability, and in our situation here, employment, discrimination, and failure to act in accordance with the law. And there are a few additional characteristics of class actions that are very interesting. The first is that the court must certify the class, meaning that that class of plaintiffs meets certain criteria. The class representatives must also give members of the class the right to opt out. And that's important because some of the class may not want to be bound by the court's determination. So if the court or the parties come to an agreement, then those members of the class who have opted out will not participate. In cannabis, we often see class action employment cases arising from wage and hour claims, labor claims, and retaliation and discrimination claims. For example, here's a few. Bud tenders have alleged that other employees are being paid a higher portion of customer tips, or where a large cannabis grower failed to provide meal and rest periods, or a dispensary has misclassified employees as independent contractors. And we will talk about that topic a little later. Just last week, this is an oddball case. Just last week, a class action lawsuit was filed by 24 unlicensed dispensary operators against the city of New York for the city's unconstitutional closure of hundreds of illegal businesses under the Smoke Out Act. Often the claimants file suit for millions of dollars in damages. Many of those cases settle without disclosure of the settlement amount. Most of these cases are exceedingly expensive to employers. For example, MedMen settled a case in California for greater than $1 million on claims by the class that they were not being paid for off the clock work. So what do cannabis employers do to avoid or minimize the risk of employment class actions? Our distinguished panel is going to suggest practical efforts you can implement to minimize that risk. So let me now turn to the panelists. Brian, you're first up. Then Janet, I've got some questions for you. Brian, how can effective onboarding or offboarding processes help to mitigate the risk of a class action in cannabis?
Sure. So before we talk about how onboarding can help mitigate the risk of class actions, it's important to remember what kind of the fundamental element of a class action is, which is commonality. Class actions happen and get certified when a violation is not just unique to one employee or to one person, but is common to the entire set of employees. So the purpose of onboarding and preventing class actions is largely going to be focused on cutting out that commonality tag. And there's a few different ways in which onboarding can do that. The first is making sure that you've got to make sure that your policies are in place. The policies that you have in place are complying with the law. That you don't have any policies that are going to generally violate wage and hour laws or anything else like that. And then in onboarding, you're going to want to train your people to make sure that they're following all those policies, and that with every employee that's onboarded, they're trained to follow the lawful policy, so that if someone comes back later and tries to file a class action, you can say, well, we had a policy that was lawful, and we trained every employee in that policy to make sure they were all following that lawful policy. So if maybe one or two employees didn't follow that policy, that's unique to them. It's not a common thing to all employees. Make it an individual suit, not a class action. And that's kind of the second aspect of this, is that you're making sure that that training is applied to every employee, that everyone's complying, that everyone signs forms saying that they've been trained and acknowledging they've been trained, and all that good stuff, so that you can be sure to make that argument later on that any violation that occurs is a rogue manager, rogue employee, something that is individual, not the basis for class action. And then another very important part of the onboarding process that can help mitigate the risk of class actions, in most cases, not necessarily all, there are some exceptions. Talk to a lawyer to determine which exceptions apply in your particular case. But generally, in a lot of cases, you can have employees sign arbitration agreements that waive their right to bring a class action lawsuit. If it is legal to require that, then it's a very good idea to have that requirement, and to have your employees sign arbitration agreements that waive their right to bring class action lawsuits, because we've got that actually going in one case right now, where the plaintiff filed a class action lawsuit, found an attorney to file a class action lawsuit, and the employer did have proper arbitration agreements in place. The other side ultimately agreed to move to arbitration and to get rid of the class action, and that's converting claims that were, exposing the defendant to over 7 figures of liability to claims that should be under 6 figures, even in a worst case scenario, which is great for the employer. So you want to make sure that you have agreements in place as part of the onboarding process to you can limit the exposure to class actions at the outset. Now, at the offboarding stage, you also have an opportunity to mitigate the risk of class action. Offboarding is when you get your chance to make things right with disgruntled employees, possibly offer severance pay that would, again, include a waiver of class action. You can use interviews during offboarding to determine if there are any general common issues that could create a risk of class action, as opposed to individual issues that can be limited to liability for an individual suit. and also gives you an opportunity to document any problems with an employee if the employee leaves on bad terms, so that you can reference that for future legal action, both just as a substantive defense to the lawsuit, but also to, again, be able to tell a court, these are not common problems that the employee is raising. These are problems that are unique to this employee and therefore should not be a class action. Because again, as Janet said, for a class action to get past that initial stage, the court has to make an initial finding that a class should be certified and that the case should be a class action. So that your whole goal in onboarding and offboarding with respect to class actions is to break that link in the chain, to make sure that a court does not certify the class action by making sure that any problems are problems unique to an employee rather than common to all your employees.
Thank you, Brian. Appreciate it. Janet, Brian talked about effective onboarding and offboarding primarily for the purpose of diminishing the court's opportunity to certify the class. But what other critical elements, policies and procedures, for example, that you believe should be included in the employee handbook to keep these kind of lawsuits at bay?
Well, the handbook is an opportunity for you to ensure that you're communicating the lawful, comprehensive policies and procedures, both from a federal and a state compliance perspective, and actually lay out exactly what these are, how you as an employer are going to treat each of these. And it allows the employee an opportunity to review. There are several different critical sections in which a handbooklet should include things such as an EEO statement, which the discrimination, making sure that employees understand that you're compliant within the EEOC requirements, making sure that you have all your policies and procedures spelled out. Workplace policies and procedures should include and address the hiring, the attendance, your payroll, how you handle time off, any cybersecurity, media, then also your health and safety. How are you going to ensure that your employees understand what the safety policies are and what the requirements for injuries are and how they report those? What is the communication within the organization? How our employees interact with each other, with customers, vendors, and what is a process internally for all of the communication in order to address any type of policy violations or even federal or state violations, so that you can mitigate and correct anything that could lead down the road to a class action. You want to make sure that you're having a code of conduct and what is considered unacceptable behavior that you have zero tolerance for, and ensure that you have that spelled out so that if in fact there is behavior that is violated, it's all documented. And you want to also make sure that each employee receives at the onboarding process this handbooklet, that they review the handbooklet, that you receive a signed acknowledgement that they have read it, and you maintain that acknowledgement on file so that you can provide proof that you've supported lawful activities, you've communicated what those lawful policies and procedures are, and that the employee has been provided documentation and a copy of all that.
That's one heck of an answer. Thank you, Janet. Quite comprehensive, but I do want to give an opportunity to Greg and Mike to add their points in this particular direction with respect to onboarding and offboarding, tricks, policies and procedures, all intended to minimize the class action risk. Who's taking it first? Greg, you going?
Yeah, I think employers can mitigate risk by using a technology platform like we have with Greenleaf HR for an onboarding process, that starts the conversation for compliance reasons. It allows employees the opportunity to set up their tax withholdings, then transition through the various HR-related documents for organizational acknowledgments for FMLA and sexual harassment, and then as Janet mentioned, go through the employee handbook and sign that, either hard copies or wet copies, for in a digital environment. And then if there's any employee benefits that need to be signed up, and sign the correct documentation for that. I think that would be helpful. And in regards to offboarding, same thing. Technology can do a lot of this for you, because we're all human and we make mistakes, and it can be easy to overlook an important step. Is something as mundane as like a COBRA package, for employee benefits, that can lead to problems down the road. So I would encourage all employers to, if you're not going to outsource your back office admin, at least invest in an HRIS that will provide that necessary support.
Thank you. Mike.
Yeah, what's interesting is a lot of the disputes that we're talking about specifically are usually inadvertent. Sometimes they're explicit by business, but they're typically accidental. And clarity and consistency for us is a really important component when we talk to these businesses. Keep in mind, people tuning in, watching this, and that are going to be joining the industry shortly, there's a velocity of growth with which you have to contend with, right? You are going to go from a singular store, maybe from a handful of people, where it's easy to do onboarding on a recurring basis and doing documentation and having acknowledgement of the job responsibilities and company policies. Those are things that should and typically can be executed well. I think the problem, the friction that starts to exist, is when you start seeing a velocity which these companies grow, and by virtue of that, it swells. The responsibilities of people swell, their job formation, the organizational design swell. And then most importantly, you start seeing instances of people looking for a career path that you haven't constructed for them. And what you start seeing sometimes in the first instance of termination is the fact that you have to start thinking about offboarding what was originally a core team that you didn't really expect to. The interesting thing about offboarding, final settlements, reason for termination, company property, right, the legal ambiguities. The thing that's really important to emphasize is that a lot of the people that are in the managerial position to execute on these needs, they themselves are not trained, or they come from a practice or from a focus, a discipline like cultivation, where the idea of having, overseeing dozens of people is a new and relatively novel experience for them. They've grown weed at scale. You couldn't see it prior. It might have been a clandestine practice. So first things first is to make sure that the people that you have in the position of manager, they themselves feel like they can handle crucial conversations. They themselves can conduct an exit interview that's appropriate, that's widespread, that maybe even is proactive, that can actually prevent it from escalating into a class action. And keep in mind, a class action is just one way in which these grievances manifest. The other that we also see, which is, I think, a little bit more profound and changes the complexion of the business, is also unionization. If there's inequity with compensation, for example, or it's unclear about job responsibilities, it might not turn into a class action. Much more likely it is for someone else to represent these grievances to be reconciled with their employer. So again, it's not just about having systems architecture, which people here can talk about. It's not about understanding the litigious avenues where these employees can actually seek remedy. It's about your managers being able to train themselves in order to train others. I think that's a very important distinction, especially since these people go from a small middle manager to a regional in quick succession. So I would say preemptively and proactively train, and most importantly, get ahead. As the arc of your growth trajectory starts to escalate, start preparing for the next iteration of your business in terms of role and responsibility.
I'll ask Oh, go ahead, Janet, please.
Yeah, I would just like to piggyback off of what Mike and Greg said, which I think is critical. And oftentimes with employment law, it's ever changing, especially within different states. So having to keep up with all of the constant changes is almost a full-time job. So having a partner that can assist and notify you when these employment laws change and your compliance changes, whether you grow from a 15 employee group to a 50, and what the federal changes are, and then where you are within states. Every state has different types of compliance laws that may even be more generous than the federal. So keeping up with all of that is a real challenge. And I advise businesses to make sure they have a partner that's going to assist them with keeping abreast of all of the changes.
And if I might follow up a question with a question. Mike, you talked about how rapid the expansion growth of these companies has been. What we've seen, someone who is now an MSO, multi-state operator, may have started 20 years ago with one dispensary. So the question is, how many of you recommend also teaching, training the executives? Now that there's an executive class, yeah, it could include the founder, but generally the bigger these companies get, the more they have outside directors. They bring in exterior managers, management officers. Should those people be trained as much as people on the floor?
Absolutely. I think it was directed at me, but I'm just going to jump in all the same. I think training in cannabis has to be a constant and consummate experience for everybody for a host of reasons, one of which is the very people that you're going to hire at the lowest rung have different expectations from a cultural perspective, from a different expectation in terms of benefits. One of the things that you have to do is not just understand the legal ramifications and the obligations as an employer, but also what does workforce development look like in contemporary America? Right now, as we speak, cannabis is just one specific subset of industry along a larger macro environment. We're not separate from that. We're looking at the same talent pools in many instances. So training, not just in terms of an orientation around what cannabis is as a space, as an industry, and all of the ramifications that come with that, which are significant and severe. It's also the fact that you need to, if you're bringing someone that is from a contemporary business that has a director or a VP title, and now they're going to be a named executive officer, right? They have broken through some kind of fourth wall, and they're going to be put side by side with the founder or a cohort of other people that actually kind of spawned the business. One of the things that is very important and consequential to ask them to see is, are they accustomed to the entrepreneurial experience, right? And the fortitude and the grittiness and the resolution, the determination that you have to have for that. Because sometimes groups work for major corporate businesses that have layers and layers of middle management where issues are easily, they're almost kind of siloed and they don't necessarily come up. They don't escalate. In this paradigm, they do. So I think training is constant. I think it's not just about what you have to do from an obligation standpoint. It's what do the people that you're bringing at the lowest rung, what are their expectations? How do I train them to make sure that they evolve? And also, it's a financial imperative. How do I make sure that my churn or my burn or my retention and attrition rates are not significant or severe? So I think training is a constant. I think it can be done in accordance with this growth trajectory that we're talking about. I do also say that it's not just a static book that someone gives you. I think the best way to learn about all of these ramifications is to create a mentorship experience. There are other operators that have been in existence for quite some time that could teach you in real time and talk about the efficaciousness and the variety in which they have solutions for some of these issues. So surrounding yourself not just with best-in-class vendors, much like us, or legal expertise, but also other operators who have gone through this iterative process, that's very consequential, very consequential.
Greg, did you want to add something to that?
I don't think I could follow up with on Mike's
All right.
good explanation there. Great job, Mike.
Great one. Thanks, Mike. Let's go back a step. what, Janet, and I'd appreciate others chiming in, what specific wage and hour issues are most frequently litigated in class actions? What are we seeing? What are the claims?
Misclassification, I think, is very big. Whether they're identified as an employee, which they're receiving a W-2, or are you identifying them as a contractor? The IRS actually, writes the definition for what a contractor must do and be in order to be a contractor. So that's one. The other is identifying employees as exempt versus non-exempt. That's another issue that a lot of businesses, I believe, think, oh, well, we pay them a salary, so we've met the definition of what an exempt employee is. And it's actually much more than that. And making sure that you're auditing your positions to ensure that you really, truly are meeting the classifications correctly based by what the IRS or the Department of Labor have published.
Agreed. Brian, along those lines, talk to us, please, about how employees versus independent contractors are classified. And also we should talk again about the following up on Janet's point. We ought to be examining the exempt versus non-exempt classifications.
Sure. So as to the independent contractor versus employee distinction, a really important wrinkle here is that it's not the same rule in every state, and it's not the same rule in state versus federal. There are two really big kind of tests at opposite ends of the spectrum for for the question of whether personnel should be classified as an independent contractor or an employee. At the kind of strictest pro-employee end is the ABC test, which California and lots of other states follow. The ABC test assumes that personnel is an employee unless it is proven that the personnel should be an independent contractor. And there's three different prongs that all have to be met. It's an and test, not an or test, for the personnel to be considered an independent contractor. Those three prongs: first, that the worker is free from the control and direction of the hiring entity in connection with the performance of the work. So in layman's terms, means for an independent contractor, you can't tell them how to do the work. You can't tell them when they need to be at the office. You tell them this is the job to be done, and they get the freedom to decide when and how they complete it. And that, importantly, needs to be considered both under their contract and in fact, right? If you have a contract that says they're an independent contractor, but in practice, they always have a supervisor telling them where they have to be and what time they have to be somewhere and what time they have to get the work done and how they have to get the work done, then they are an employee under the ABC test. Second prong that has to be met is that the worker is performing work outside the usual course of the hiring entity's business. So independent contractors should be doing something that's outside of the core business of what you're doing. If you're a cannabis grow facility and you're hiring employees to handle the grow and handle the growing operations themselves or the cultivating, right, that's all going to be part of your core business. Independent contractors are going to be generally going to be doing things ancillary to your business, like, say, having someone from outside the company handle your HR paperwork, or having someone outside the company handle transportation issues or other things that aren't part of the core of your business. If the personnel is doing work that is within the usual course of your business, they're an employee. Third prong is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature that's involved in the work performed. So you have a worker that, say, is an independent truck driver. That might be someone who's an independent contractor. They have their own truck, they're doing their own work, they deliver you contract them independently to deliver things and transport things. That's an independent contractor, as opposed to someone that doesn't have an independent established trade. You hire them to perform secretarial work. You hire them to perform, grow work, or to process flour, or whatever you're having them do, that they don't have their own independent business separately. That's going to be an employee under the ABC test. If the contractor doesn't meet all three of those prongs, then they are considered an employee. So the default here is that they're considered an employee. There's a different test that's applied in a few states, as well as, importantly, generally under federal law, called the common law test, that assumes that a person is an independent contractor and not an employee, unless the employer is controlling what will be done and how it will be done. So, really just focusing on that first prong of the ABC test and really just applying that. So the federal, the common law definition, which is what the IRS uses, is a lot broader and gives you a lot more scope to identify personnel as independent contractors. Big caveat to that, law is constantly changing, and there's a huge debate that is constantly raging among both the administration, within the Department of Labor and other executive branch officials, and also within Congress, as to whether to switch from the common law definition to the ABC test at the federal level, with the Democrats generally preferring the ABC test and Republicans generally preferring the common law test. And we'll see how elections and bureaucratic wrangling goes in terms of how the law evolves there. But if you're looking at that standard, it is really important to stay on top of that test, and that's one of the reasons that you hire employees to help you make sure you're hire both attorneys and hire outside HR people like everyone else on this panel, to help make sure that you're complying with what the current law is and that you're staying on top of what the current law is.
I understand, panelists, that some companies have taken the wrong course, and they have classified everyone that is working with them as independent contractors. I understand that when the state or the feds find that violation has occurred, there can be substantial damages assessed, and attorney's fees, perhaps, maybe interest, additional taxes. What do you collectively know, and can you share with us concerning that kind of situation, if you've had that experience?
Well, it was interesting. So Jason DeSense, who's typically on this panel, very handsome gentleman, you all know him. When we were working on a specific project, so oftentimes where we see a really large friction point is during the process of integration or divestiture. What we start seeing in both instances, and what we've seen, is as you look into the instance of exempt, non-exempt, you see a lot of misclassification. You also see grievances by virtue of that. So we saw unpaid overtime, meal and rest break violations. Off the clock work was a very large issue. Incorrect pay rates is very typical. And a matter of fact, again, I think that's one of those, it's an accidental byproduct of a space coming to terms with what the work actually entails for the title that you're giving it. And then record keeping violations. One instance that we saw was actually during the Cresco, what is now the Cannabis, but Columbia Care divestiture. We had to look through some of their and this is all public information. We had to look through some of their HRIS infrastructure and their architecture to see past grievances and issues. And they had done, and this is, again, it's published, they had misclassified a huge swath of their hourly workers and some of their VPs on retail. And the consequences, I think the judgment was a low seven-figure number, if memory serves. So significant. And the interesting thing is it was, again, not an explicit action by anybody. It was the fact that these businesses ballooned in size, and so did responsibility, and they had not revisited this topic. One of the things that we always do when we take on a client is we do a thing called yes, no day. If it's an integration, exempt, non-exempt, this new person coming into the organization and under this new design, tell us specifically, based off your understanding and basis of knowledge for the state that they're in, as well as the expectation of the role that they're going to have, if this person is exempt, non-exempt. I don't think businesses are reapproaching that enough. And I think during integration or M&A activity, I think they're not bringing that to the forefront. I think that's a afterthought. I think it should be front and center. First thing that you do is thinking about how you are classifying these people.
One thing I'd add from a personal experience of mine, and it also kind of goes to the issue of dealing with the independent contractor issue in M&A context. One of the cases I had involved a giant multinational, huge international company, name you would all recognize, but I'm not going to tell you what it is, that had a general practice of using a lot of external workforce. Because prior to the changes that led to the ABC test, following the common law and the independent contractor definition, there are a lot of economic advantages to having external workforce, having outside people manage their managing payroll, managing all the aspects of employment that your company doesn't want to handle. When the ABC test started getting into place, that company, and we don't know for certain that this is why they did it, but we have a pretty good guess this is why they did it, was ultimately decided that to avoid the risk of liability that came with incorrect independent contractor classifications, they had to effectively insource, we'll call it, thousands of employees. They had to take these external employees and try to hire them themselves, bring them inside to avoid the potential liability that came with things like misclassification as independent contractors. Our client in this case was one of the vendors that had some of that external workforce, and there was a big contract dispute over the way that the giant multinational handled it. But it was a big enough issue that the company needed to spend millions and millions of dollars dealing with the problem. And it's a problem that is probably something that you have to deal with as your company grows and the potential liability from an external workforce grows. Especially the bigger company you have, the more likely you are to have kind of these ancillary external work employees that may become regular employees, that their jobs may become more core to your company's business as you get bigger and require that kind of reclassification. So it is a very big issue that you need to deal with proactively, or risk some very large liabilities, very large risks.
We've been talking about larger companies, but there are so many more small to mid-sized companies. So, Greg, you mentioned using software programs to assist. Tell us more about those programs that you can provide, and what's the goal of bringing that kind of program online?
So most small and medium-sized businesses outsource either a portion or all of their back office administrative duties. And it makes sense because of the cost of labor. So our company leverages technology to streamline back office administration from the very first moment for recruiting all the way to onboarding, the HR part component there, and all the resources that we have available for these companies. And as Janet mentioned, the multi-state organizations and the different legal complexities with onboarding for organizational acknowledgements, employee handbooks, safety manuals, and the list goes on and on. And then the whole goal of streamlining that, but remaining compliant. And that's really the goal for our company, is to ensure compliance from all facets of employment law.
Janet, want to add something to that?
I think it's also another feature that an organization like us brings to the table is it gives the business an opportunity to discuss with the professionals what exactly the options are. They can present, their situation and really kind of drill down into what's going to best fit my business, my culture, my needs, and really tailor it for each client. I think that's a big critical piece of what we do.
Brian, let's assume that this is a small to a mid-sized company, and it is learning that the potential that a claim may be made. The potential of a claim is there. What should that company, particularly its management, be doing to try to either fend it off entirely or minimize the risk?
So a lot of the things that you would do as a smaller to medium-sized company when faced with a potential class action lawsuit are the same sorts of things you do when faced with the potential for any lawsuit. One of the obvious first things you're going to do is check your insurance. Make sure, hopefully you have insurance that covers the claims an issue. If there's coverage, make sure you get a claim out there, because your insurer may be the one who appoints the attorney rather than you. You don't want to go out and hire an attorney yourself and then find out that you shouldn't have done that because the insurer should have been paying and the insurer is going to get its own attorney. Other typical things that you're going to do in any litigation case, send a litigation hold letter, make sure that all relevant documents are preserved and that everything you have relevant to the issue is preserved, so there's no danger of sanctions down the line. If you don't have insurance that get an attorney for you, then obviously get an attorney yourself. Make sure you start talking to attorneys, get all your ducks in order, start figuring out your strategy, and figuring out that strategy can be a proactive thing, right? If you see the issue coming down the line where you haven't been threatened with a lawsuit yet, you can start doing things like talking to the potential aggrieved employee to try to cut them off with a settlement in advance. Have them, give them severance pay in exchange for waiver of relief or waiver of class action, of their right to bring class action.
But not fire them.
Not fired, yes. you don't want to retaliate against the employee, obviously.
No. Right.
But yeah, that's another thing to talk to your attorneys about what you can legally do. Conduct your own internal investigation. Make sure that you've confirmed that your policies are in order, that whatever issue that you've spotted is unique to the employee rather than hopefully common to all your employees. And if you need to correct the policy, then sooner is better than later. Generally, again, you're looking to stop the class action aspect. You're looking to cut off the commonality. So you're looking to make sure that it's a unique issue or an issue that you can settle out the individual employee rather than it turning into a class action. But that on top of the sort of typical things you do with any litigation in terms of trying to settle it ahead of time before you get to court, before you have to spend all the money on litigators. I like it when you go to court and you spend money on me, but you probably don't like that as much as I do. So talk to the lawyer beforehand so that you can try to avoid court and try to avoid the class action in the first place and limit what you're paying the attorneys.
It seems to me that one of the up and coming areas in employment class action is workplace safety. We saw recently, this has been pending for a while, but it's hit the news again, lawsuits by, I imagine it was state health and safety agency against True Leave for the death of a young woman who had been working in the cultivation facility and allegedly inhaled cannabis dust and etc. I saw another similar case reported recently as well, and I don't recall the state. But workplace safety programs have to be updated, upgraded, and then communicated, don't they? I leave that to the group to discuss.
Yeah, I'll take that. I think that you have to start with the basics, especially with newer organizations. You have to start with an OSHA compliant safety manual. That's first and foremost. That's required by law. Same with an injury and illness prevention program, and then establish a return to work program. And then we talked a lot about training and training. A lot of companies overlook that aspect of safety and health in their workplace. You can use technology. We have an integrated learning management software that has more than 300 different trainings available to organizations. They can include in the onboarding process and throughout the year. And you can even create your own training regimens and upload that into our system. But document. Always ensure that you document the time, location, and the attendees of who participated in that training, and make it consistent. That way, if you ever have to call Brian, you'll have the documentation to hopefully ward off a potential claim. Mike, do you want to follow up on that?
Go ahead, Mike, or Janet.
Or Janet?
Brian?
What's interesting is the idea of risk assessments, potential hazards that are specific to the cannabis space. We have so many instances of that are documented but not shared. And I think that's an important distinction. Right now, as we speak, there are people that are doing sub and supercritical extraction, taking these cannabinoids out of the plant and putting it into products downstream, right? The interesting thing in terms of safety policies and protocols and procedures, identifying those risks in those tasks. Where will you get those? Where did they come from? Is the equipment the same? Are the materials the same? Is the size and the scope and the responsibility of the site the same? Is the training, to Greg's point, is it robust? Is it regular? And then more importantly, even if all of those things are in place, which is saying a lot, maintenance. One of the things that's really important is ensuring that all your equipment is properly maintained. We hear that constantly from our vantage point about HVAC systems and or accidents by virtue of the fact that maintenance is very slipshod. Also encouraging reporting, right? Not just saying that you have it, but making sure that people feel comfortable in talking about and reporting those safety concerns without fear of retaliation is really consequential. I think one of the issues that we see with some of the larger organizations or larger facilities is that some people feel like, well, it's not my problem, right? I'm doing my job. I'm not necessarily responsible for the maintenance versus escalating the idea of maybe this should be maintained. But I think the thing that has always absolved a lot of businesses and falling into the trap of a class action potentially is conducting regular audits, right? Really looking and periodically reviewing safety programs and addressing new risks and ensuring compliance. When we see businesses that go from several retail stores or a larger production site to a huge production site or a cultivation site that has modular grows and builds alongside it, that will not change necessarily the cadence of the overall work, but it could very much change the potential hazards, right? So I think that's one way that companies can get ahead of it, which is periodically looking at the growth trajectory of their business, or just periodically knowing that they're going to do regulatory audits to make sure that the programs are assessing new risks and new dangers.
Do we see laboratories? Many states are requiring products be tested before they're sold. Do we see those labs having any unusual safety issues simply because they're handling so many products, or are they virtually the same type of issues?
Well, I'll take that one to start since I'm talking. We just had this conversation too recently.
Oops.
The issue with labs is not because the certification process to be a lab and the process. Typically, labs are very good at actually creating contained and defined environments to having to handle custody of some of these products for quality control purposes. The issue really with them is the fact that the motivation of reporting from labs has created a schema where people are being disingenuous about their processes. They're being disingenuous about the efficaciousness and or what are inside of these products. We constantly see recalls. We constantly see those issues. So I think it's less about the safety concern for the people inside the lab and far much more about the safety for people with these products outside of them.
Which of course could initiate a class action lawsuit.
I think that is something that we have yet to see that is potentially on the horizon, considering that the number of units sold, Michigan sold 24 million units just in May. That's 7 million more than California. Just to give you an idea of proliferation, I would say that is much more a danger point for these businesses than they are from a lab perspective.
Okay, then what about extractors?
Well, the interesting thing about the lab extraction process is they're
No,
very
not well. Yes, a lab, an extraction from flour, for example.
how it's dangerous or how it's
Because oftentimes it uses certain either additives or water
oh, I
processing
see.
or what, right? And so
Sure.
would they typically have more fires and other workplace hazards?
Well, we have seen a lot of illegal locations literally explode because of the fact that they're using critical components that are very hazardous and combustible. I mean,
Right.
again, most of the time when people are actually creating these extraction plants, they're usually having a brain trust of people that are creating enough of a buffer, enough of a process to make sure that that specific instance doesn't happen. However, the onus really isn't necessarily on the extraction to make sure that the products themselves are safe. They put that to the lab. What the labs are trying, or what the extraction facilities are trying to do as much as possible is throughput. They're making sure that they can escalate and have throughput on a recurring basis for supply needs. But very seldom do we see anyone getting hurt or maimed in extraction. Usually we see the instances of unregistered, unregulated sites. Those are extremely dangerous and have been in the news much more than usual production sites.
Well, we're getting very close to the end of our time. Let's just open up the floor. Anyone want to talk about any particular topic with respect to employment issues and the possibility of a class action?
I think I would just want to emphasize that when we're talking about class actions, the whole reason that we're concerned about class actions as opposed to any other legal issue, relative to other legal issues, is it's just the power of multiplication, right? It's the fact that a class action with 100 employees can turn a $10,000 claim into a $1 million claim, and can turn a $100,000 claim into a $10 million claim. So whenever we're talking, when we're talking about the cannabis industry, it's an industry that is relatively new. It attracts a lot of people who are more freewheeling, entrepreneurial, maybe want to move faster, not worry about compliance as much. And with respect to individual lawsuits, maybe you can sometimes get away with that, but class action lawsuits, because of that power of multiplication, really do have the power to destroy you in a way that individual lawsuits often don't, and also gives plaintiffs' lawyers an incentive to bring them that individual lawsuits often don't. So this is a really important topic that you should be very concerned about. Even if you're willing to put up with the risk of loss, even if you're more willing to put up with the risk of individual lawsuits, these are really scary and dangerous.
Thank you, attendees and panelists. Very wise words from this distinguished group. We obviously all have a lot of work to do in minimizing class actions. Please, attendees, give us a few comments or two if you need further assistance. We really appreciate your attendance today. And panelists, thank you so much.